get us started. Thank you.
Thank you, Ryan. I appreciate you putting us together today for this. Brief introductions. My name is Rosalind Cresswell. I'm from the Mass Office of Public Collaboration, and I'm the Grant Program Manager for the Community Mediation Centre Grant Program. Also, Kayla, do you want to introduce yourself?
Sure. My name is Kayla Allen, and I am the Program Director of a Dispute Resolution Center administered by Berkshire County Regional Housing Authority. Thank you for having me.
So the plan today is we're going to briefly explain who MOPC and the Community Mediation Centres are and what we do, give some information in general terms about mediation, and then talk about mediation specifically in the context of housing eviction cases. At the end, we're hoping that you'll have a good sense overall of who we are as a network, some clarity around our mediation services, and our expertise in this particular area and how we will all work together going forward. We'll try and keep track of the questions as we go along and answer them as we go. And we can also answer questions at the end. Okay, so starting off with what is MOPC? We get called MOPC, MOPEC, all sorts, but it's MOPC. It's the Massachusetts Office of Public Collaboration. We were previously known as MODA, the Mass Office of Dispute Resolution, but we're the state dispute resolution agency, and we're also an applied research center based at UMass Boston. What we do is we provide, the office provides services to the 3 branches of government through expedited procurement. We use ISAs between state agencies for those. And we serve as a neutral forum for conflict resolution. We expanded our name from dispute resolution to public collaboration because of our role in helping build consensus in public decision making and around building capacity with public agencies. So we wanted to broaden it to include those areas as well. And we build and administer evidence-based public mediation programs, of which this is obviously going to be one. Next slide, please. So what is state-sponsored community mediation? It's a statutory program that's been sponsored since 2013 by the state under the legislation named there. And it's administered through MOPC as a performance-based grant program. Annually, we go through a grant-making process with all of the centres, of whom there are currently 12 in our network. They're all non-profit community mediation centres, and they provide services across all 14 counties of the state and 72 court divisions. Many of them are very long established local community organizations. Some of them have been recently celebrating their 30 and 40-year anniversaries. So they've been around a lot longer than our sponsorship of them or administration of the program has been. The program through us offers a way of accountability for the public investment from the state. We do an annual program evaluation that's shared with the legislature and on our MOPC website. And it has shown an annual rate of return of investment from the state of 12 million through the cost savings brought about by conflict being handled in this other way, in the alternative ways that we do, and the leveraged resources, including the volunteer mediators that we use. Okay, thank you, Ryan. So what makes community mediation different from any other private ADR provider? So the community mediation centres that we partner with as part of their grant approval comply with a 12-point model of standards that we developed when we designed the program back in 2013. And those standards focus on 4 key areas: service to the local community, access to services, quality of the services, and diversity, including both diversity of the types of cases that we deal with, and engaging with diversity in terms of people who work for the program and the people that we serve. As I already mentioned, the centers are embedded in their local communities as conflict resolution resources. They all offer free and low-cost sliding-free services, part of the Access to Justice initiative that we contribute to. We provide the services through well-trained volunteers. They have to meet continuing education requirements, and they practice a style of mediation called facilitative mediation, which means that rather than directing a process, it's often said that the mediators control the process and the parties can control the outcome of the mediation. So it's geared around their particular needs, and the mediators just help them through that process. All of our community mediation centers are approved providers for the trial court under the Uniform Rules on Dispute Resolution. Okay, oh, we're going backwards. So who are the centers and where are they? There's a lot of detail on this slide, and it was just to give a general sense of the fact that we are spread from the western part of the state in Pittsfield, which is the center that Kayla is from, right down to the tip of the Cape, and also have a center on Martha's Vineyard. So we cover the whole of the state geographically. Okay, next slide. So who community mediation centers serve? We're often asked this question. We've recently been involved in a marketing campaign, and obviously that was one of the key questions. Who are you trying to message? And the answer is pretty much everybody, because everybody has conflict in their lives at one time or another. But these are some particular examples of the types of cases that mediation centers generally handle. So working in neighborhoods broadly and specifically between neighbors. So complaints perhaps about noise, property, animals, lifestyle differences between neighbors, between roommates, those kinds of cases. Workplace conflict between co-workers, between supervisors and their employees. Businesses. The centers do a lot of consumer and business to business, community business cases, particularly through the small claims work that they do in the district courts across the state. They do a lot of work with families. So divorce mediation is a type of mediation that's very commonly understood these days. But they also do specific custody and mediation to retain relationships as well as break them apart through divorce. They're involved with parent-teen mediations where there's often some behavioral issues, and also several of the centers also engage with elder conversations around estate planning and disputes about care and who's going to control the keys when the parent wants to continue driving when they shouldn't be. So those sorts of conversations. Communities and local government, so conversations and collaborative decision-making around land use, decision-making around school districting and use of public buildings and that kind of thing. Support to faith communities around policy planning and hiring decisions, landlords and tenants, which is obviously the meat of what we're talking about today, and shared housing, condo disputes, living conditions, roommate disputes, as I already mentioned, and then eviction and homelessness, obviously prevention, which, as I say, we're talking about today. And a lot of the centers also do work in schools, either providing services for mediation between pupils about disputes, between pupils and staff, and parents and staff problems, as well as going into schools to help work on the environment and the culture of the school. Many of them are operating those sorts of peer and conflict programs within schools across the state. Okay, next slide, please. So in addition to mediation, and we've talked over the years about whether community mediation centers is still the correct term, because centers are now providing a range of additional services. Those include restorative practices, often used in schools and in youth diversion away from the criminal justice system. They can be either used as an actual restorative process when harm has been committed, but they can also be used to build community within organizations. Centers do work around conflict coaching. That's usually when they can't get two people to come to the table for a mediation. They can work with one particular party and help them think through the conflict and the best way to approach it. But also people come to them just for general conflict coaching, skills building, particularly business cases. Centers help facilitate conversations amongst groups. We run a program with re-entering prisoners, providing services pre-release to allow people who've been incarcerated to have conversations with their significant partners on the outside, which can help ease and facilitate that release process. So we have currently 6 programs involved with that. Many of the centers provide conflict training, both in terms of training new mediators to join their programs, but also general conflict training for their local communities. The youth programs in schools and outside we've already touched on, and deliberative dialogue, again, around community decision making. So they're all a wide range of different dispute resolution practices that the centers provide. Next slide. So some of the impacts of community mediation, as we've already talked about, they can work with families in conflict, reduce neighborhood conflict and violence. Obviously, the work that we do in district and juvenile and family and probate court helps mitigate overcrowding and long waiting lists for cases. The work that we do with youth addresses both youth violence and bullying and resolves issues which can lead to misschooling. And again, relating to the juvenile cases, prevents criminal records among youth for minor offences that can be settled through mediation or restorative practices. Supporting re-entry and pre-release, reducing homelessness, providing access to justice. It's another tool in the belt of ways in which access to justice can be granted. We work on promoting community building and support local officials with public problems when they arise in local communities. Next slide, please. Okay, so that's a very general overview about MOPC and the community mediation centres. Over the last year and launched back in January, we started a new website basically for the process of getting out information about community mediation as a whole network across the state. There is a website and you can read more about all the things that I've just been talking about. If you want to know more about what particular services a local centre provides, then you can read all about it on the website, which is www.resolutionma.org. Okay, so that's some general a general overview of the program. We wanted to talk a little bit about mediation. It's a common joke amongst mediators that people often misread it as meditation and turn up for entirely the wrong process. But it's not a very well understood process. So we wanted to just briefly outline what it was and what it isn't. So there are several principles which we'll come to on a later slide, but basically it's a voluntary and confidential process which is facilitated by a neutral third party, in this case the mediator or mediators. They prioritize self-determination and informed consent of the parties to reach a mutually agreeable outcome or progress towards one. Not every mediation results in a full agreement, but often it moves parties forward from a situation where they've become stuck. Depends on the type of case. Obviously, if we're in court, we're looking towards a particular agreement. But if we're talking about the types of mediations we do in families, often it's just improving communication. between members. What it isn't is it isn't an adjudicatory process. So the mediator never takes sides. They don't advise, they don't make recommendations, and they don't direct the parties. This is part of the facilitation process that I mentioned earlier. And it isn't about dragging people into some kind of middle ground. Often people come into a mediation assuming that everybody's going to give up a little bit and then we're going to try and settle on something in the middle. And I'm always at great pains to explain that sometimes that is exactly what happens in a mediation, but a lot of times it isn't. Often when people have a chance to hear each other and find out what's important to them and how they can get what they need, then I've seen parties say, okay, now I understand the situation better. I'm quite happy to accept something much less than I came in here asking for. So it really is about helping people explore what's important to them and how they can achieve it. Okay, next slide. So the 5 principles of mediation, which are taught at every basic mediation training to mediators, are that it's a voluntary process. That's for both the mediators and the parties. At any point, if people feel that mediation is no longer appropriate for them, they can withdraw from the process and they don't give anything up along the way. I'm going to go to confidentiality last because it kind of ties in with that. Confidentiality is also very important in mediation because it builds the trust and the ability for people to be able to share what they're most concerned about in the process if they know that it's not going to be shared outside. And so if people do decide to go back and give up the mediation, then anything that has been said in that mediation is maintained as confidential. There are a few exceptions which programs often operate around risk of harm and criminal activity and things like that. But basically, the mediation process itself is kept private and confidential, and that is agreed upon in writing by the parties at the start of the process. There's a Massachusetts law which protects that mediation confidentiality, and signing of that mediation agreement at the start of the process is what kicks that confidentiality protection into place. Excuse me, I'm going to have a sip. For the parties, informed consent is a very important part of mediation. Mediators will always want to ensure that the parties understand what they're getting into in terms of the mediation, that they understand the rights and obligations and have been able to seek advice before entering into the mediation process so that they can make a decision based upon that. As we said earlier, it's entirely self-determined what the outcome looks like. Disputants have a right to define their issues and needs and determine what any kind of an agreement would look like without the mediator telling them what that would look like. So again, a very important element. And then the impartiality, or sometimes called the neutrality of the mediator. All the participants have the right to a fair and open process where everybody's treated equally. The mediators don't take sides or give advice to one party against the other. And so the mediator acts in this impartial role where they use a non-judgmental process to help the mediation process go along. Okay, next slide. So some of the benefits of mediation. People often use the language win-win as opposed to win-lose when talking about mediation. So that's a very commonly understood benefit. But it gives the parties a sense of control over the outcome of their dispute, particularly when people are in court and it's a situation's being adjudicated by somebody else. They're going in and handing over the responsibility for the outcome to somebody else. But in this case, they're having the ability to control that themselves. And this is something we often reinforce in mediation when people are getting stuck, that this is an opportunity for them to have that control and not cede it to somebody else. The outcomes are reached collaboratively, and are therefore more lasting and more adhered to. Research has shown when people have that control over the outcome, they buy into it more strongly than if they're being told what to do by a third party. Gives the parties a chance to speak and be listened to. This has surprisingly not often happened before. People get into situations of conflict and then shut down communication. And very commonly in mediation, we hear, this is the first time we've had a chance to sit down together and talk this through, or this is the first time they've understood some aspect of the situation. So it's definitely very valuable from that point of view. It allows for very creative and flexible outcomes. So again, a legal process in court may result in very constrained and limited agreements based on the legalities of the case. But a mediated agreement allows for all sorts of negotiated settlement and details that can be brought in, and flexibility around how and when things take place and who's responsible for them, all of which are worked out in the final mediated agreement in detail. Mediation's usually cheaper and more timely than legal action, and can also happen upstream, which Kayla will be talking a little bit more about in a minute. So working around conflict preventatively as well as after the event. The mediation centers, as part of their access, offer services both preventatively when the conflict's very low, and in preparation for it escalating, but also right up to when it's very severe. So having that range of opportunities available is obviously it's good to be able to work with people at the preventative stage, but centers offer services all the way through the whole spectrum. And finally, it helps build and retain relationships. This is obviously especially important to ongoing ones. So in landlord and tenant situations where there's been an existing relationship or a tenancy over a period of time, it can make a really lasting agreement where people understand each other's situations in a far more complex basis than it would if they went into court and resolved it on a very much a win-lose basis. We talked earlier about retaining relationships in families. It's particularly obviously beneficial in those circumstances. Okay, next slide. All right, so that, and I'm not able to see the chat at all, so I'm
Questions yet, so.
no questions yet. Great. Well, we will look forward to those. Look forward to those at the end. So I'm going to switch it over to Kayla, and she's going to talk now more about mediation in the context of the EDI.
Thank you, Roz. So what I'm going to do is talk about, like Roz said, specific mediations relating to housing and this eviction diversion initiative. So I'm a very visual person, and I created this chart that you see here to show where we may get involved in the eviction process. So historically, mediation has been available in most areas and in most courts on the trial date. So landlord files, you wait till the trial date, then they get an opportunity to mediate, and either they come up to an agreement and it gets filed with the court, or they don't, or in the event they don't want to mediate, it goes forward to a hearing. With this expanded visual here, you will see that we can get involved now even before a filing in court. So landlord provides a notice to quit, and a referral can be made right to one of our mediation centers, which we're calling pre-court diversion. Parties either agree to enter into the process and come up with an agreement, or they don't, or don't want to mediate. But there still is then the next opportunity to enter into mediation after the filing of the summary process complaint, but before the trial date. Right now in the trial courts, they're not doing hearings, so they're doing these case management conferences. So if it is court involved, it's usually falling in that pre-hearing diversion option. But obviously there still will be the opportunity to do mediations on the hearing date. Next slide, please. So we are going to talk in a little bit about the benefits of accessing mediation pre-court, but there is one part that I wanted to mention, which piggybacks off of what Roz was saying earlier about what the principles of mediation are. And the one I want to highlight that's specific to these housing situations is, next slide, please, informed consent. So in our community mediation cases, there isn't much that is always going on with informed consent. There might not be a lot of law at play. It might not matter that individuals have information on what their rights are or not, because that might not be involved in the dispute. In almost every housing situation, it's really important for both parties to know what their rights are and what they are agreeing to. So as a mediator, we have the duty to make sure that that happens. And so the way we do that is not by telling parties, okay, this is what this means, and this is what this agreement will mean to you, and this is how you will be advantaged. None of that. We just want to highlight the information that parties could benefit from having and make a referral either to legal services or an HCEC. So let's say, for example, a tenant is being charged illegal late fees. In a mediation, I might say, okay, it looks like there is some more information that parties need to gather so that they are informed when participating in this process. Let me make that referral out, and then you'll come back to the table knowing kind of what your rights are and what you're agreeing to. Because the biggest thing as mediators is we do not want to do any harm. So we don't want to enter into an agreement with parties where it's unknowingly disadvantaging someone. And so a big thing here is just making sure that they have access to that necessary information. As mediators, we're balancing a number of interests. And so we're always trying to figure out how to make sure parties have informed consent while remaining neutral. And so I think a really nice part of this diversion initiative is that we have the time to make these referrals so that parties are coming in ready to mediate and they know exactly what it is that they are going to agree to and adhere to. Okay, so I want to give an example of what we're currently doing, and then I'll talk a little bit about how this would differ from our diversion options now. So right now, let's say tenant and landlord are in court with a non-payment case. This is an example we had where they hadn't paid for 2 years, totaling almost $19,000 in rent arrears. The tenant filed an answer and was claiming the landlord hadn't addressed repair needs, rat infestation, lack of hot water, a floor that the tenant fell through. And through mediation, the parties agreed that the landlord would waive rent arrears, court costs, and allow use and occupancy for November and December, as long as the household vacated by January 1st. This resulted in the tenants not having a judgment entered against them over 2 months to find alternative housing, with the landlord avoiding having to levy that execution and to pay storage charges. And so in this situation, it kind of goes to show what we are doing in mediation. We try to find what is most important to parties. And in this one, it was clear that the landlord wasn't as interested as getting that money back, but instead getting possession of the unit. And so then through mediation, we're making sure that it's realistic and it's fair for the tenant that they have time to find alternative housing if they're agreeing that is also the best way forward. Now, let's say that now we have this expanded diversion initiative. This case could actually be referred to us before it gets to court. And so perhaps they're being looked at for financial assistance. But then there's still an issue maybe of the excess money that financial assistance won't cover and all of those repairs that need to be taken care of. And so that is something where if you are working in a program where it's going to fix some of the problem, but not all of it, then we want to get involved. We want to then engage in a mediation process to where the tenants and landlords are getting the necessary resources and that they are finding a resolution to everything in the dispute, not just one piece of it. And so I think sometimes it's challenging before when we would get this type of case in court and they have a hearing a half an hour later. we want to make sure that before we have the time to really address all of these necessary things.
So Kayla, there's a question here about mediation in housing court where people feel forced to take the offer on the table, and a question about how the mediation process is going to change the current stigma of mediation at housing court. And I can see, yeah, and Josh, thanks for for responding in the chat. The housing court does use a program called housing specialists, as Josh mentioned. They are separate. They're trained by the trial court. They're not actually related to any of our community mediation centers. So these would be different programs that would be dealing with these cases. And I'm sorry to hear that you've had that experience.
And thank you for pointing that out, because I'm so used to just saying courts. And when I say that, I do mean district courts. So all of our mediation centers, if we're doing summary process evictions in the court, it is the district court, because as Roz said, housing court has housing specialists. So thank you for flagging that.
Can I just weigh in and just mention that under the Uniform Rules on Dispute Resolution, the housing specialists do what's called dispute intervention. It is not called mediation because it isn't completely confidential. They do have to report back to the court, and because of these other dynamics. So mediation is different from what the housing specialists do in dispute intervention.
And I think historically, it's been difficult for landlords and tenants to decide, okay, do I want my case to be heard in housing court or district court? There's different benefits for each of them. And so I think with this option now available, if there's a situation where there's something going on, even before having to decide, okay, do I want to go through housing or district court, referring to one of our community mediation centers will then have you definitely going through this mediation process, this facilitative model that we've been talking about. Next slide, please. Okay, so this is kind of on top of what I'm saying. We're really encouraging this pre-court option because it has so many benefits. On top of what I've already been saying, it is cost effective. So landlords don't have to spend the money pre-court to file in court yet, and tenants don't have to be responsible for that amount. And so sometimes that can really help people. It's also quicker than a traditional court process. So as we know right now with the CDC moratorium, cases aren't even being heard in court. So they're having these case management conferences, but then essentially what's happening is it's getting pushed out a couple weeks and then maybe pushed out a couple more weeks. And so what happens if a referral is made to one of our community mediation centers is we do an intake and can get it started right away. And so because there has been no movement from March until now, it's really nice that we can offer this in a timely manner. Additionally, it allows more time to access necessary resources. So I think the whole idea with this eviction diversion initiative is that everyone is coming together because we all have different strengths to help resolve a dispute or an issue or a housing crisis. And so when we're getting things at that last minute in court, it's really hard for us to connect individuals to other resources or have them be connected to us in an effective way. And so I think doing this all before it even gets to a hearing or even a filing will just help significantly with the situation. Next slide, please. Okay, so I'm sure this is on everyone's mind. When do you refer to mediation? And so we have outlined here a few scenarios on when you would want to make a referral to a community mediation center. So after RAFT eligibility is determined by the HCC's or RAA staff, this is when you would want to refer. Let's say the parties cannot reach an agreement after receiving assistance from the RAA or the HCC for whatever reason. So there are still existing issues that are needed to be discussed. Please make the referral. Let's say the RAFT math works, but the benefit is not enough on its own to resolve the issue. So the RAFT funds would make a difference, but the landlord is resistant to signing the RAFT contract because they may have to forgo rent arrears or accept lower future rent. So that goes back to the example I mentioned where they owe $19,000 and RAFT might not cover all of it. So we kind of open up that conversation to see how there is a way where they can get the financial assistance and still stay in the unit. And so it's talking about all of those other things. Mediation can be really helpful when one party is represented by an attorney, but the other is not. So oftentimes this creates a power imbalance, and that's something that we can work through through this process. Or a party is simply requesting mediation to resolve the dispute. What we will do when we get that request is we will screen it and see if it is appropriate for mediation. And more often than not, there are things to discuss if they're making that request. And so we can go through mediation on that side as well. This is for all of the other EDI agencies. If there's a high level of conflict between the parties and relationships are frayed, please make the referral. A lot of the times in these tenant landlord situations, there's a lack of trust, but there's a need to have this working relationship moving forward. So it might not be something tangible like money or something like that, but there are parts of the relationship that need to be discussed. Communication problems may exist between the parties. That happens a lot. Communication drops off. Different levels of knowledge and access to information. As I had mentioned before, that can also cause a power imbalance, and that's something that we can address. Additionally, if the issues are complex, involve multiple parties, and or require specialized expertise, that is when mediation can be helpful. Next slide, please.
So there's a few questions come in which just relate to that. From Annette most recently, how do we work through a power imbalance if a tenant is unrepresented and landlord is represented?
So a big thing with power imbalance is not that we're necessarily giving the other party more power, but we want to empower them with self-determination to make their own decision, and that they have a right to define their issues as well as the landlord. So let's say landlord's represented and they're coming into court saying that the tenant owes them money. A lot of the time the tenant feels like they don't have a leg to stand on, and anything that they wanted to bring up, they can't, because they feel disadvantaged and they feel powerless. So a lot of the times what we will do is work to make sure that the tenant is expressing everything that they need to as well, and that they are not almost kind of being bullied by the other party just to agree to something. We may do this with both of them together, or we do go into private sessions a lot with the parties, but it really is ensuring that this process is going to empower everyone, and that they both are going to define what their rights are, what their issues are, what it is that they feel comfortable agreeing to. And additionally, if someone is unrepresented, then they kind of goes into informed consent. They may not know what their rights are. They may be disadvantaged in that way. So those are things that we're not going to tell them what their rights are, but we're going to flag it and give them the opportunity to get the same information that the landlord has.
And Rochelle asked if both parties have to request mediation. If one party is interested, the case can certainly be referred over, and then the mediation program would reach out to the other party to see if they were willing to be part of it, because as we said, it's voluntary on both parts. And also a question about who would be validating the agreements. Do tenants and landlords just sign off to avoid court? I'm going to hold that one, if that's okay, Esther, till the end. It's a somewhat of a complicated answer, so if I haven't answered it by then, flag it up again for me.
And this next slide kind of goes into if one party is interested and the other is not. Oh, back one. Thank you. So we wanted to put something in here on how to introduce mediation to parties. So it is not our expectation that you explain everything and anything about mediation just to get them on board. We would suggest that instead of asking if they want to mediate, instead indicate, I'm going to be making a referral to a community mediation center so you can learn more about mediation to help resolve your issues with a neutral third party. The reason we say that is because sometimes individuals don't know what mediation is or what it entails. And a lot of the times what I have seen is a landlord or tenant will say, oh, we tried that before and it didn't work. And that might be anything from like trying to have a conversation over text, or maybe trying to have a conversation with someone else. But what the referral will do is it will get us to us, and then we have the opportunity to talk with them to see if it is right for them. And a lot of the times we're addressing certain concerns to get parties on board with mediation, to get them feeling comfortable to try out the process. Ultimately, it is voluntary, but I think it does need to have a larger conversation with the centers, so that we can figure out, okay, is it that they really don't want mediation, or they just don't know what it is about and what it means for them? Examples of what can be mediated, I kind of put this here, just to touch on the other things that we didn't mention, is sometimes payment arrangements, realistic move out plans, communication issues, conversations around repairs. So if you're talking with someone, you can say, okay, well, I noticed that this is still something that needs to be worked out. Maybe mediation would be the right step for that. But I think ultimately the takeaway here would be that you have the power to make a referral, and they then have the power when they're talking to us to say no, or they don't get back to us. But I think just to get it off of you, just indicate that you're making the referral instead of asking them if they would be interested. Next slide. So we do have a little information on what the referral process will look like here. This came out of a conversation with providers the other day, and it is a now approach. So once we are given feedback, it may change in the future. But I want to highlight that regional and local arrangements and relationships are key. So I am working for a mediation center in Berkshire County. So if you're someone in Boston, we may not ever interact. So I think it's important after this to see who is your local community mediation center, and maybe make that connection, because they will be there to answer questions that you have, and they will be there to help you work through this new partnership. And so the referral process in general, though, referring agencies will use a case referral form, which is being worked on, to send parties to the case coordinator at their designated local community mediation center. Referring agencies will receive confirmation from the mediation center that the case has been received, or that the referral has been received. And then the HCECs may be contacted by the mediation center course coordinator if additional resources are needed to settle the case. Cases will be put on hold while RAF eligibility is determined. But ultimately, if a mediated agreement is reached, it's up to the landlord and the tenant to take it to the HCEC, just to loop them into the process if that's needed to do whatever it is on their end. So this is still being worked out a little bit, and I know we're going to keep talking about this, but this is generally what has been come up with so far. Next questions. So I see a couple of questions on here. Oh, I see a lot of questions on here. So we're going to take questions now. Let me see if I can make this bigger. All right, Roz, I don't know. I can't scroll up for some reason on mine. If you want to. I have a question here. Conversations around repairs. How or who would be following up to make sure the repairs have been made? So with repairs, a lot of the times there are status dates, or we continue the mediation to ensure that it is continued to be looked at and monitored. A lot of the times the Board of Health gets involved, and so sometimes that might be what the parties are working off of to ensure that they are both agreeing to what repairs are needed. But with repairs, it is something that the mediator is going to keep checking in on, and that's usually with a subsequent session that is scheduled.
So I've scrolled back, I think, to the earliest one that we didn't get to, which was about housing court case specialists and whether or not they've had restorative justice training, and is it known? The housing specialists in the housing court are nothing to do with the community mediation centres, so we don't keep records of what their training is. They receive training through the trial court, as far as I understand it, so we wouldn't have any information about their additional training.
And And additionally, with restorative justice processes, a lot of mediation centers do use that approach for certain situations, but currently with these housing type situations, it's solely mediation.
So there is a question about having some eviction cases in Roxbury District Court and never having been offered mediation. Do they have to request it? So first of all, a lot of eviction cases go now directly to the housing court rather than in the district court. So I'm not every program is in a court at every session. So if there's mediators available in the court while you're there, then that information should be made available to you on the day. But if you haven't been hearing that there's a mediation program available in court on that day, it may be that there aren't any there at that particular session. We talked a bit about validating agreements. Yes, if the referral is outside of court, it would be a written mediated agreement, and it would be in effect a contract between the parties.
And sometimes, a lot of the times what I see is if we're entering into an agreement outside of court, and let's say it ultimately ends up in court, that is brought up and is usually taken into consideration.
Stephanie says, just to clarify, as far as raft math working, if the raft math works, it's likely the landlord would agree unless there are other circumstances such as repair issues, etc. By definition, it doesn't work if the landlord has to take a haircut. That might be a term of art with which I'm not familiar and is resistant. And from the RAA standpoint, that is when they would likely refer to mediation. So as Kayla said, this is very much a now process. We had this discussion the other day about referrals and what they would look like. So it's a process that's in development, let's say. I think we'll be talking about it on the Friday call again.
So there's a question, how do you ensure that a tenant is not giving away legal rights without a meaningful consultation with an attorney? And so that is where we say with the informed consent portion, we want to make the referral so that they have access to that information, whether it's legal aid or another resource where they can consult with someone that can give them that information so that they know exactly what it is that they are agreeing to.
And then there's a question about how people will know about making the referral, and is the raft application put on hold? So this is, community mediation is one of the agencies that's involved in the whole of the EDI. It's a tool that is available, and there are referral forms which are also in the process of being crafted that any agency could use to refer a case to a different agency. They've been very generally written in such a way that any of the agencies can take them and use them as a referral tool. So there's checklists on those to make sure that the correct information is being passed between referring agency and receiver. So that's how that process would work. Those forms, I'm sure, will be coming out within the next couple of weeks. They've been worked on quite closely, I think, by all the different agencies with input. And no, as far as I understand it, the raft application wouldn't be put on hold, but the reverse is true. The mediation will be put on hold while a party worked with a raft agency.
We also have a question here. After a referral to mediation is made, how long will it take to set up the mediation? Is it a one-time mediation session or a series of conversations? What happens if the mediation process is not over and a case is filed in housing court? So it's different for every center. So I don't want to give an exact answer of how long it will take to set up. But what I will say is with this expansion, each center is hiring at least one full-time case coordinator who is going to be doing the screening and intakes for these referrals. So the mediation should be scheduled fairly quickly. And it's different. So sometimes it is a one-time mediation session. With these situations, it's likely going to be a series because, as I mentioned before, like let's say with repairs, that's something that has to happen before the conversation can continue. But that is it. Again, that will differ situation to situation. And typically, if parties are going through the mediation process, they aren't going to be filing in court quite yet. I think the understanding is that they're both coming at it to try to avoid court. But if they are going through mediation and a case is filed in housing court, I'm not sure, because again, we don't do much in the housing court. What the housing court would do in district court, they would continue the case so that mediation can still occur.
And it's also possible that a case that wasn't settled in mediation pre-court could then come up again downstream when they get to court, and there's no reason why the parties, you know, couldn't try mediation again if they wish to, if they were both willing to do so. There's a question about limits to eligibility. So the steps that Kayla outlined before flag the types of cases that you can refer over to mediation. The case coordinator would then do a screening intake, and they would then make the determination as to whether or not the case was suitable for mediation. So there may be certain circumstances if there's if one of the parties says that they're not interested, obviously then it would be ruled out because of the voluntariness of the process. But also, if it was clear that one of them was so skeptical about the process that they weren't entering into it with any intention of settling, that might also be something that could be screened out at the beginning. But otherwise, provided they meet the criteria we talked about earlier, then they should be referred over and allow the case coordinator to do the screening.
There was a question about RAFT, and if there's a payment agreement made, clients are no longer eligible for RAFT. Is this agreement different? So as Roz had mentioned, if they are eligible for RAFT, then the mediation is going to be put on hold, so that can be taken care of. So that should.
Yeah, Dave mentioned as well from TPP that they were setting up regional meetings so that the EDI providers could meet and discuss their programs. So when Kayla referred earlier to the importance of the regional relationships, that would be the first step in everybody getting to know each other and figuring out the on-the-ground processes for making those referrals. He says you should be receiving an invitation by the end of the week or very early next week.
Another question, is there a sense if the referral forms will be standardized across programs or each have their own? I'm pretty sure they're going to be standardized. And especially for the mediation centers, those are going to all, at least the referral to the mediation center will be standardized. And then another question, so if they aren't a good fit for mediation, or let's say they decline to participate in mediation, then would they be referred to legal services? So that's when our case coordinators, who have been also on all of these other trainings, are going to determine where the appropriate referral is. So if it's not legal services, maybe it's TPP or something else. So they're then going to do the work to figure out where can they get the appropriate services.
So a question about the looping back process, if the RAFT process would have to be put on hold if the mediation was still pending. So as we said earlier, at the end of the mediation process, then yes, the parties, if they'd reached an agreement in mediation, would loop back to the agency that was supporting them so that their RAFT contract could be drawn up using the terms agreed to in the mediated agreement.
So I think with like, yeah, like raft and if what's being put on hold, I think it's a case by case basis. So if it's something where the mediation agreement needs to be reached before there can be a raft determination, then obviously it is going to be the other way around, right? So I think it's who needs what from who and in which order, and then it will be determined what will be put on hold and what won't. And sometimes we're mediating in conjunction with the raft being processed. So,
But the raft determination would generally have been made prior to the referral being made to community mediation.
and Jane, you might mean like the specific award, right? In terms of treating somebody at the HCEC level to find out if the $10,000 can work at all, it's sort of a chicken and egg. We need to know ahead of time if we know we can. I can't hear you, Jane.
Yeah.
Brad just put in the chat.
Yep.
And yeah, I just want to clarify, Brad and Cassie are both chiming in here that if someone comes in through the HCEC RA door and then is referred to community mediation and they've been determined eligible for raft, and then they go to community mediation and that needs to be worked out, then their application will be on hold until community mediation has time to refer them back with hopefully a contracted deal, a contracted mediation. That then the raft agency can then further process the application. I think the complete timing of that we still need to kind of work out of application can be put on hold. But yes, in general, we understand that raft application needs to be put on hold while community mediation has time to work through the process.
I think that's all the questions.
On the last slide, there is contact information for Roz and myself if you do have any lingering questions. And Ryan indicated that the recording will be posted online later this afternoon. So you'll have that information later today.
Yes, this recording of this and all other trainings that we have done so far and will be doing in the future are all going to be posted on that website along with the PDF copy of the presentation that was used today. So it's easily shareable amongst your staff and anybody else. I'm also going to put my email address in here as well in case anybody has any specific DHCD questions. Feel free to reach out directly to me. And if there are no other questions that pop up, feel free, like I said, to reach out to any of us. And thank you all for taking the time to join us this morning.
Thank you.
Everyone.
Thank you, everyone.
Thank you.
Thank you.